Hello and welcome to Lean in Ushuru. I am your host, Wanjiru Mwangi, a HR leader and a life coach. I am passionate about helping women see themselves confidently, be seen boldly, and thrive in every aspect of their life. We have been having such amazing conversations in this season, and today is no different. We have a guest, her name is Leah, and we're talking about one of the previous episodes we talked about financial protection. So then how then do you protect your family? It's just having peace of mind. And we're going to talk about trusts, wills, and all that comes with having the conversations that happen after you're gone. Leah, welcome.
Thank you.
Please introduce yourself and tell us a bit about yourself.
All right. My name is Leah Kigwatha Muteru. I am an advocate, a lawyer. I run a law firm called Kigwatha and Company Advocates, and we mainly do real estate and family law. We do mainly family law and some real estate. Mm-hmm. Yes, I'm also a mom. Mm-hmm. I have 2 kids, and I'm married to my husband Muteru. 16 years. I think it's going to be our 17th.
Oh,
I don't know where the time goes. We think we are young. Until we say this year will be our 17th anniversary.
Oh, wow.
Yeah.
Really happy for you. That's good. So thank you so much for joining us today. And we are going to have a conversation that's not very comfortable. We're talking about wills. It took me forever to do my will because we kind of want to live forever. You don't want to imagine that I'm doing in case of I die, what's going to happen? So what is a will?
A will is a written, it's a written document that indicates what you want to happen to your property when you pass on. Because it's inevitable. You know, death is inevitable. We are all headed there. So a will is that document that you put together. It's a legal document, so the law says certain things about how it should be done.
Yeah.
But it is a written indication of what you want to happen to your property.
Yeah.
When you pass on, you need to have 2 independent witnesses who witness it. And they know that they are witnessing a will. And these 2 people can't be beneficiaries in the will. So you can't call
my children.
Yeah, your 2 children, and then it's the property you're giving them in your will. So that's why you need 2 independent witnesses for it to become a will. Yeah, just writing down and leaving it without witnesses, it doesn't make it a will. So so it's a legal document indicating what you want to happen to your property.
Okay.
Once you're gone.
Interesting. And the fact that you need 2 independent witnesses.
Yes.
What happens when I just write my wishes down?
Those are wishes. And so, so because they are wishes, it will now depend on your people whether they want to honor them or not to honor them.
They don't hold water.
Yeah, it's not, you can't go to a court and say this is, one person will be saying this is what she wanted, the other person will be saying, but this is not a will. Maybe there are some other wishes lying around somewhere. So you'd have to, if you want to make it a legal will, you need to do it properly. And you need to also make sure that you have 2 independent witnesses.
Okay.
Yeah, who are not beneficiaries under the will.
I think it's very interesting because I know not so many people have written their wishes down. So in spaces, they have a will. They have a will written down that has been witnessed and stuff like that. Yeah. Some of us will whisper to our friends, like, if anything whatever happened to me, this is what I want done. That does not hold the water in court or anything.
And you see, that's what people think. It's an oral. You can have an oral will, actually.
Tell me more.
You still need 2 independent witnesses.
So you need to have told 2 independent people?
No, they need to be together as you tell the both of them. And then you have to die within 90 days. Of that will, unless you are, in the army or in the navy and you're going out to war, then you leave your wishes with 2 independent, 2 independent witnesses, and then you go. Then maybe you die 6 months later.
Yeah.
But for a normal everyday person, if you just leave an oral will, if you say this is what you say, and then there are 2 independent witnesses, but then 7, 8 months down, you pass on. As long as it was done more than 3 months ago, then it's not valid.
Okay.
Yeah. And then another thing is that you can't revoke a written will with an oral will. If you have a written will, you can't now come and say, I have a will and I'm revoking it orally or verbally. and then with your two witnesses, that even if you do it properly and you don't put it in writing and you don't do another written will, then that oral will cannot revoke the written one.
This thing is a bit more complicated than it
It
sounds.
is actually. You do need to sit down with a lawyer to do your will. And I know there are wills on the internet. And, you could, get your two witnesses. You could do that.
Yeah.
But then, some mistakes we get into is that now the witnesses are the people who are also,
beneficiaries. Yeah.
You're willing away property that you shouldn't be willing away.
Oh, is that property shouldn't be willing away?
Especially men. The property that is in your wife's name that you decide you cannot
will it away.
Or if you own property jointly with somebody, you could will it away by saying, if the person dies before you, this is what you want to happen to that property.
Okay.
But if you die before them, the property becomes automatically theirs if it's jointly owned.
Oh, really?
Yeah, so you can't be willing away jointly owned property.
No, wait. So
you can only will it away by saying, if so-and-so dies before me and therefore this property becomes mine, this is what I want to happen to it. But if it's jointly owned, you can't will it away.
And my part of the joint?
And we'll talk about that when we move away from wills, because there's a way that you can own property so that you may not write a will, but at the point of purchasing it, actually, if you look at a transfer of property, whenever there are two people purchasing a property, there is an opportunity to indicate how you want it owned. And at that point of purchasing, you could actually make sure that the property is registered in a way that speaks to how it will be owned when you pass on.
Should anything happen.
Yeah. So if you want me to talk about it right now, I could go
Please
into it.
because it's very interesting. I'm like, oh, Lord.
Yeah, I know. Yeah, no, this is, now we are digressing.
That is important information.
But you said it's a women's show.
It's a women's
show. So this is how we talk.
I know.
1 minute you're talking about.
I know, but
and that's beautiful. I think it's a wonderful thing.
It is.
So, okay. So if you own property jointly with somebody, so at the point that you're purchasing property, if you're more than one person, at the bottom, not even at the bottom, just under the names, when you put, you put in the details, name, the purchaser, the transferor, the transferee, their PO boxes, their PIN numbers and all. There's usually a small sentence where you indicate, if you're more than one, how do you want the property to be owned? So will you be owning it jointly or in common?
Jointly or in common? I know jointly. What is in common?
Jointly is, it means,
it's
when you write jointly,
Mm-hmm.
it says Leah, it means Leah and, when you choose jointly, Leah and Wanjiru, it means if Leah passes on, Wanjiru takes it absolutely.
Wow.
If Wanjiru passes on, Leah takes it absolutely.
Did you know that?
And and other people can't come for it.
My next of kin, my husband can't come.
Which is why, actually, they'd want to. Which is why it's important. If you own jointly with somebody other than your spouse, please tell your family. Because, for example, let's say I own with my sister Wanja, my baby sister, she's called Wanja. Let's say Wanja and I buy property and we put it in joint names, okay? If I pass on, it becomes Wanja's, absolutely.
Oh, wow.
But my kids will be left feeling that Auntie Wanja owned property with mom. How is it possible that it's now automatically Auntie Wanja's and we don't have a share?
But legally it is.
But legally it is. It's called the doctrine of survivorship, and that's how it works. So the best people who, if you want to protect somebody like your spouse, okay, you want them to have this property once you're gone, and it is them you want to have. You don't want fights about it. You can register it jointly, because when if you know that you have relatives out there, that your brothers will come after, to destabilize your spouse, put it in joint names, and then it automatically becomes your spouse's. Now, if you do that with anybody else, please inform your family so that they are not left feeling like the other person took it away. And I always advocated for jointly owned property for a long, long time. But you know what happens with age? things, such situations come up, and then you
It's
start to
true.
wonder, was joint the
I
best,
know.
the best option? I remember a client of mine. She was in her late 60s, and they were purchasing property, her and her husband, and they had sold some property and they were purchasing a new one. And this new one, she insisted she didn't want joint. Because I always assumed if it's a husband and wife, then put it in jointly. And she said no. And he was there. It was a very interesting, I think women, we get married, I think we lose a bit of power, but years down the line you
find
regain
yourself.
it. Because because I remember she was in her 60s. He was seated there. It was not a hidden thing. She was saying, no, I don't want it to be jointly owned, because if I pass on, it will be his, and then he'll marry somebody else, and you know, and he could transfer it to her or to her children. So I actually want it to be in common, in equal shares. So that's the other way. If you are going to own with somebody, you could do it in common in certain shares. So you can say, we're going to own this in common 50-50, or we're going to own this in common 60-40, or we're going to own this in common, you know, 30-70. So now when you do that, if you pass on, so let's say you, Wanjiro and I, and Leah, we purchase property, we say it's in common 70-30. Okay? Wanjiro's share is 70%, my share is 30%. So what's going to happen is if I pass on, okay? My family will have access to my 30%.
It's very clear.
And you keep your 70%. Okay? It's not, it's the opposite of joint. You see, joint, one person passes, it becomes
the
absolutely the other person's. Then if it's in common, then your share then remains in your estate. My children can have it, and then your 70%, you keep it.
Oh wow, that's
so so that's a good way of also thinking about it when you're getting property, you're co-owning in you know in different situations. And so like people, please, I'd like to just say something to if you're a registrar of lands and you're watching, please honor that when we put in these transfers, because sometimes you put in a transfer, you say 70-30, then the title is brought back to you, and it just says the names. It doesn't say how the people are owning, or then there's, you know, or you put it in and, you know, they don't put, is it jointly, is it owned in common? And yet it's very clear in the form that was formulated for these purposes. But that's the idea behind the law. So now back to wills. Don't will away your jointly owned property unless you say, if the person passes on before me, which then makes this property mine. So that's something that we need to think. We need to think about. If it's in common and you put it in your will, then it is your share in that property.
That's very
that you're putting in your will.
So even as a couple, as a married couple, you can do register in common.
Yeah, you just need to indicate, because if you're a married couple and you don't indicate if it's in common or it's joint, the presumption
is that it's 50-50.
Is that it's jointly owned.
And jointly owned, it's 50-50.
No, well, it's 50. Jointly owned is 50-50. Has a presumption of 50-50. If you're dividing matrimonial property. But upon death, if you're both alive and you're dividing matrimonial property, it's 50-50, okay? But upon death, it's not 50-50. It is the doctrine of survivorship comes in, and the survivor takes everything.
That is so interesting. And I think it could save people so much heartache.
Yes,
because we find ourselves in spaces, and this brings a lot of chaos that really are avoidable. But it's because people do not know.
Yeah.
People do not know this information. I personally actually didn't know about the registration in common. So it's actually very, very
there,
interesting.
now you know.
Because you also find yourself in spaces where you have joint property. This person goes and gets a second wife, or you divorce and you had...
Actually, that's what I was saying. I always say do joint, do joint, do joint. And it's... So when it's joint and you go into a divorce process, of course the presumption is that it's owned 50-50. So it protects you. But if you pass on, if you pass on and then it becomes the other person's, absolutely. Let's say you married, it's a second marriage. So I was faced with this situation. Somebody came and said, you know, my mom and my dad owned a property. Okay? jointly. And then my mom passed on. Okay? And then my dad later married somebody else. And because it became his absolutely, he put her on the title.
It has happened
But
a
we
lot.
all know that this is our mom's property.
It has happened
So
a
it
lot.
became jointly owned property with the new wife. And then the dad passed on, and the new wife was left with this property. She was the same age as the kids. They're in their 40s.
Oh,
they're
wow.
hustling. And so they can't believe that their mom's property
Is getting into...
is it. And I suspect that lady who came to me, that older lady who had come to me many years, many years earlier. And I mean, I was in my late 20s and I didn't understand why she would want it in common. This is probably what she was thinking, because these guys knew this is our mom's actually, they felt it was their mom's property that she had put in the dad's name to be joint owners with him.
Yeah.
But now it was gone. It was no longer available.
You left with such angry children.
Exactly. And it's really, yes.
Yeah.
And you didn't intend to.
It's true.
You didn't intend to. You intended to leave something for your children. So like this lady, my client, I'll always be grateful for her.
Yeah.
Because, she was about 40 years older than me, but she had such wisdom and she really opened my eyes, to the realities of life. And she was there was nothing, there was not a fight.
Yeah.
And, he was just there nodding, thinking, yeah, actually.
It's something having...
Put it in common.
It's very, very important. I have realized that sometimes when you're getting married, you think love is enough. Love is everything. You're so in love, you forget that there are so many other things that...
There are many other,
that
I think that's the thing. That's the reality of life. Love is wonderful.
Yeah.
But there are so many other things that you
need to consider.
You have to consider. You have to have wisdom.
It's
as
very
well.
true.
Even God asks us to love Him with our hearts and also with our minds that He gave us.
It's very true.
So if God allows us to limit or to regulate how we love Him, He says, love with all your heart, with all your mind.
Yeah.
With all your strength, that tells you something, that even as you love somebody, love them with your heart, but also love them with your mind.
It's very true.
And love them with your strength as well.
Yeah, use wisdom as well. That is very true. So you talked about there's a way you can be able to, when you're buying property, and especially we are talking about, we have modern families where you have that person, you coming with your own property, I'm coming with my own property. It's a blended family.
Yeah.
You had your own investment, I have my investment. I want to protect my children, you want to protect your children. How then can we ensure that we are working together and this does not become an area of contention?
Yeah.
What can we
do? What you could do for property that you already own, and you're thinking, because today we are talking about estate planning, so we are thinking in terms of death. And you see, death is inevitable. I think many times we are afraid that if we make certain decisions, it looks like we are not trusting our partner, or we are not trusting in how long this love will endure.
Yeah, and forever.
Yeah, but you see, death is inevitable. That's
true.
the thing about death. There's some decisions that you need to make with death in mind. So for example, you could think, let's register all our property jointly. But now that you know that what will happen upon if you pass on, then you have to think, I'm not saying that this person will leave me. I'm not saying that that our marriage will break down. But what if I die? What happens?
It's true.
So in a blended family situation, you need to think about what do you want about your property to happen to your property if you pass on. Is there property? Because you see, when you blend a family and you both and the children are now, you take on you take somebody's children in as part of your family, and they take on their children in as part of the family. Depending on the ages of the children, it could create later. It could create conflict if you don't leave a will. So one of the best things to do is to leave a will and to say that that and that property, I want it to go to my children from my first marriage because I earned this property for them at that point. Subsequently, I have I have, you know, acquired X, Y, and Z, which I'm happy to open up to the children that I blended in, that I brought into the family. But then also you could write a will and say, you know, all my children, now I accept all of you. But then if you don't write a will, then a real big problem comes up where the children were brought in and they're wondering, then they start to wonder, are we entitled?
I know.
To the property? Are we not entitled to the property? So, for example, actually just this week, I was faced with an interesting situation, actually maybe 2 weeks ago, where somebody came and said, my mom passed on and my dad remarried.
Yeah.
Okay? And actually their dad didn't remarry for a very long time. Okay? So he later married somebody and she came in with 2 grown kids.
Wow.
All right? So she came into with
the
2
union
grown kids,
with
into
grown
the union
kids.
with 2 grown kids. Actually, they were in their 20s. So there's even a question as to whether they were children brought in.
Yeah.
And then their dad passed on.
Because they're adults.
Yeah, their dad passed on. So now, when the dad passed on, what her stepmom has done is there was no will.
Yeah.
So she's done a succession where she has included even her grown kids as his dependents.
Okay.
All right?
That's tricky.
And now, exactly. And his children from the first marriage are wondering, how is it possible that when my mom passed on, she left 3 of us.
Yeah.
My dad has passed on, we would be sharing the 3 of us.
Yeah.
But now these kids who came in
Now
have
we are
been
5.
included. Now we are 5.
Yeah.
And you know, the law says, well, if you hadn't written a will, then these 2 children are children brought in by the deceased as part of the family. But are they? If they came in the 20s...
I know, when do they stop being children? They never stop being children,
you see,
though.
children are considered to be, you know, children.
Until
somebody
18.
who was brought... No. For purposes of succession, like when you say children of the deceased person, it's the children that the deceased person are, even if they are grown up.
No matter how old.
But these ones who are in their 20s, were they brought in? Because so now the question is, were they brought in? When he was marrying their mom, was he thinking that she has grown children and I'm therefore sort of taking in a single woman, a woman with grown kids? Or are these 2 kids to be? And that's how fights begin. Because how do you tell them now? How do you tell her to exclude her children?
It's true. You can't.
You know?
And parents' love for their children is...
Exactly.
I love my children.
Yeah. And she's probably thinking there's property that was acquired in the last maybe 10 or 15 years, which therefore my children should benefit from. I mean, and you know, would you want to have that conversation? So why it's important in that situation, he should have left a will.
I know.
And then people would know Dad wanted us to.
Yeah.
Whether Dad considered these 2 older kids.
Yeah, it's
or
true.
whether to him it was just us who were, you know, who he had with my mom. So that's why it's important that you think about, you know, how you plan your estate before it's too late.
And such kind of things bring chaos in. You could have, this woman would have been married for 15 years and maybe they even had relationships and they were good friends. Yeah. And now suddenly, they cannot even see eye to eye.
They can't.
Because you're looking at her, this is a woman who came to steal our money, our things.
Yeah, and that our mom left behind.
I know. So it's very interesting.
Which is why I like what you said about peace. Like, the world is chaotic.
Very.
And, you know, if you think about it, we have a responsibility to create some order.
Yeah.
So one of the ways you do, that's why you need to plan. Come up with a plan, do your will, decide how you own property in a way that you're thinking ahead.
Yeah.
Think about trusts, think about gifts in survivals. Give people their gifts while they're still ahead. Because while you're still alive. Yeah. So there are different ways you could do it so that you live peace. So that you don't live fights. You create fights which were not there before. People are living harmoniously. And you know how it is, how hard it is to acquire property.
I know.
So somebody could be thinking, hey, I did not even expect to be left for by my stepfather because I came in as I was already an adult with my own life.
I know.
But hey, if it is now available, if it is now available for grabbing, I shall exert some energy to make sure that I grab something. So it can be, quite something.
We have trusts.
Yes,
Tell us a bit
we
more
do
about
trusts.
trust.
Okay. Now, trusts, what a trust is what you do with a trust is you now when you transfer property into a separate corporate entity, and that entity now owns the property for the benefit of the beneficiaries that you want to benefit. So the goodness with a trust is that the advantage is that it takes it out of the estate. Whether you have written a will or you have not written a will, if it's in a trust and it is held by a different legal entity, and then you set up a trust using a trust deed where you say the property to be held is X, Y, and Z, the beneficiaries under this trust are so and so and so and so.
Yeah.
So only the beneficiaries will benefit. And the trust will continue to hold the property even after you're gone. And the trust holds it and it continues. It is not going to be distributed, you know, like you take this, you take that.
Yeah, yeah.
What it means is that the trust continues to operate and to run, to continue to own the property. If it was a business, it continues to run the business. And then the beneficiaries get what you wanted them to get, whether it is the profits or you wanted them, how you wanted them to benefit, you continue. It continues that way. So the goodness with a trust is that it removes it from the estate. So you're not talking about probate. You see, when you write a will, you still have to go to court for a probate process where the court now confirms that the will was valid and things can be distributed according to the
will.
According to the will. So there's a court process. But when you do a trust, you take it out of the court process even. And therefore the property is held by a totally different entity. So it is advantageous for several reasons. You take it out of the probate process. It means the property will not be distributed. You know, people are usually worried, oh, I'll leave and then it will be sold within
I know, we've seen kids do
years.
that.
They're waiting to sell.
I know, we've seen them do that.
And then if you feel your parents are mean.
Then they squander that money. In 3-4 years, they're back to struggling.
Yeah, so that's something to think about. Is that you can do a trust, and then the property will continue to exist, and the beneficiaries continue to benefit. So, like if you have a child, for example, who you need. Like, you know, like if say you have a child with special needs who you know will depend on you for life,
to be taken care of.
You can set up a trust that allows the income of the property to continue to take care of that child. If you are in a situation where some people you know will come to claim, to challenge the will, to what, and you want to take them out of that conversation and you want it to benefit just a certain set of people, then you can also do that. And the goodness with trusts also, another advantage of a trust is that actually, if somebody sues you, you know, if somebody sues you today and you have preserved certain property because you want to leave it to your children, if you're sued and you lose the case, and they can come after that property, but they can't come after property.
It's under trust.
That is under a trust.
Oh, that's really good.
Yeah.
So you're protecting your kids, your future, you're hedging their future completely. Yeah,
so there are certain advantages. The disadvantages are it takes long to register. It's a process. Now it's a bit easier than it was in the past because now there's a registrar of trusts and, you know, it takes a little bit longer. So if you're on your deathbed, that's not the time to do a trust. And then I think also we are hesitant as Kenyans to now transfer the trust into another the property into another different entity. You know, you could still be the trustee as the owner of the property, but it sort of takes away your control. Even you can't sell it. You can't sell that property. You see, if you write a will, you can sell the property. You can sell the property. It's, I mean, a will doesn't stop you from selling.
You just
it doesn't.
and go and revise the will.
No, you might not even need to revise the will. What's going to happen is at the point that the will is now, because the will only kicks in when you've passed on. I think it's important to say this. The will, the effect of the will only kicks in when you pass on.
Yeah.
So as long as you're alive, nobody can hold a gun to your head saying your will says this.
Yeah.
Please give me the property that is in the will. The property is in the will is in my property. It's not your property until the owner passes on.
Yeah.
So they can sell it, they can do whatever it is that they want. If you put it in the trust, you can't sell it.
So what happens if I put it in a trust and I want to sell it?
You'd have to talk to the beneficiaries, talk about dissolving the trust. It's quite a process. Yeah, because in the lands office, it will be showing that that property is owned by the trust. So you have to bring all the trustees together and maybe even get the beneficiaries to consent to the sale of that trust. So those are the difficulties that you need to think about. But the important thing about trust is that property that is held in trust will only benefit the people who are the beneficiaries under the trust.
Yeah.
So it locks out other people who want to come and grab or to make certain claims.
And who
so
manages
that's a good
the
way
trust?
of protecting. You have trustees. The owner of the property is the settler, called the settler or settlor. If you want to be,
we're going to call it the settler.
To throw in, if you want to twang. Yeah, I meant to say settler.
Settler, yeah, true. That's the one you're sticking with, settler.
Then that's the owner of the property. Then there are trustees. So trustees are like directors of a company.
Who are they? So for example, my husband and I have a trust. Who are they?
You choose the trustees that you
like
want.
People
you could also be trustees.
Oh, we can
but
be
you
the
need
trustees.
you can also add other people in as trustees.
Independent people.
Yeah, independent people. But the trust will be an incorporated separate legal entity, sort of like a company. And then there will also be, because Kenya is Kenya, the trusts in Kenya have an additional person who is supposed to supervise.
Oh, and who is that?
Who is supposed to supervise?
By the...
No, you appoint them in the trust. Yeah.
Okay.
They are supposed to supervise because some trustees have gone rogue. It's based on on the litigations from the court. So now there's somebody else called an enforcer. To prevent the trustees from going rogue, you have somebody called an enforcer who is an additional layer of protection to ensure that it is enforced, the trust is enforced.
Do you appoint?
You appoint.
So your own
in your trust deed,
okay.
Yeah, to enforce somebody who you feel will create a balance.
So what happens when you have a trust? So let's go back to modern families. You have a trust that distributes the whatever assets that you own between, or continues dividing, owning for these children.
Yes.
Long after you're gone and everything, and then you have a will, and then you die. So, or can you have both at the same time?
You can have both. You can set up, there's something called a testamentary trust. So in your will, you can set up a trust. So you can refer in your will to the trust that you set up. So, and it's a good idea if you're going to do that, then do the trust, establish it, transfer the property that you want to go into the trust, and then in your will indicate that there is property X, Y, Z, which is held in a trust and will continue to be managed under the terms of that trust.
Okay.
Yeah. So you can have both. And then sometimes also, and that what we're talking about is an incorporated trust. But you can also have a trust that you've not incorporated, where in your will you say, should I pass on, I Lea Wanjiko Kigwatha, I ask that Wanjiro holds property in trust for my children until maybe they turn 24.
Okay.
So that property will be registered in Wanjiro's name, but it will show that held in trust for so and so and so and so.
At the registration.
Yeah. And so until they turn 24. So that when they turn 24, they need to come and tell you,
we're 24.
Please,
Happy
please
birthday.
come and yes, our birthday gift. Please dissolve the trust and now transfer the property to us.
I think what I'm hearing, and I know in African culture we don't do this a lot, is having conversations. You need to have conversations with your children, with your family. Let them know And I guess that also comes from trust. You need to build trust within your family and
Yeah.
really have these conversations such that when long after you're gone, they know we can go to Aunt Wanja.
Actually,
And
you're right,
you know,
yeah.
Aunt Wanja,
Yeah.
mommy had told us you have ABCD, and so how do we do this? Because we have seen where somebody had planned themselves, had jipangad nicely. The
But they
minute
didn't
they
tell.
die, because
Yeah.
people are people.
You know, actually, what I think is that we haven't owned property as individuals for a very long time. I think the first titles that were issued to Africans were probably issued in the 50s. Okay. Yeah, I don't think we had individually owned property. We've owned property as individuals for less than 100 years. Okay. So before that, property was communally owned. All right. So everybody knew there was a system in which property is managed,
And
because
it
it's
was
communal.
working.
It's not
Yeah.
anybody's.
Yeah.
You know,
It's
everybody
like it's
had
put in a
access.
kitty.
Yeah, everybody had, people had access. You knew this is the place where I farm. If the person passes on, if so and so passes on, what's going to happen to it from a communal perspective. And then, you know, the 1930s happen. There is, you know, there are wars, world wars. You know, we are colonized, and you know, and Britain tells the colonialists wherever they are, you manage your affairs. Don't expect us to be sending you money to your colonies. Then they sit down and say policies. What shall we do? How shall we recover? There's a global, what was it called? The depression. And what do we do? Let's make Africans registered individuals, so that this communal ownership they own is not good for agriculture. It doesn't put property in the market, because you can't sell to,
That's a good lesson.
Yeah, so no, I like to do it. I like to say this because we always think Africans, we don't like writing wills because we are afraid of death.
Yeah.
No, I don't think we're afraid of death that much. I mean, after all, we used to honor our dead.
Yeah.
You know, and, you know, we believed in life. I say we believed in life before birth, and we believed in life after death.
After death, yeah.
I don't think it's because we're afraid of death. I think the issue is that now, when now we were allowed to own property individually, it brought some problems. You know, some people were locked out. Some people were, we now created poverty. Because if you own, it's yours.
Them versus us.
Yeah, if you own, it's yours. If you don't own, if you're not on the title, it's not yours.
Yeah.
All right. And there was a lot of jurisprudence from the 60s and 70s where people were told, you know, you're holding in trust for the family. Just because, you know, people were registered. And people mainly, they took the leader of the family. And amongst Kikuyus, they even registered unborn children, because you know there'll be a boy who will be born in this family who will be called Kemani.
Yes.
So you go and register Kemani before he's even born.
Wow.
Because in our concept, Kemani was holding for everybody else. And then Kemani realized, wait, what I have is like what the white people have. I'm not holding for anyone. So there was a lot of struggle.
A bit of chaos.
It brought chaos.
Oh, no. I
but
didn't know
then
that.
I think we agreed to, we reluctantly agreed to individual property.
Yeah.
People can own individually, and we've accepted over maybe, I guess, the last 100 years.
Yeah.
But once you're dead,
Yeah.
we feel it's back to us.
It's back to the people.
I think so. That's, I think we feel, that's why people feel that like they can grab, they feel like it's not owned by anybody. And so this concept of controlling what happens even after you're gone. People feel, I mean, I remember when General Gola passed, and he had said this is how he wants to be buried. There were a lot of conversations. Why should he do that?
I know.
It is up to us to decide how he's going to. I said, even lawyers were having that conversation. I'm saying, you lawyer, I mean, are you guys serious? You're lawyers. And I said, this is why Kenyans, we don't like writing wills, because we feel that you should, once you're dead, you should
have
not be
say.
controlling. Exactly.
I know.
So I'm like, this guy decided what he wants, and we still, even as lawyers were saying, no, he shouldn't have done that. It's because his wife is from which part of Kenya. I mean, it's a really interesting thing, but because I think we think in our psyche, we think once a person is gone, it's like finders, keepers,
I know.
losers, weepers.
Do you know I know there's a place I wanted to buy land, and I was told, do not buy land here. Nobody owns land here. Land belongs to the people. I was like, what do you mean? Like, if you own land here, people need to come and graze their cows here. I was like, but it's mine. No. Land belongs to the people. Like, yo, I kind of see where it's coming from.
So we didn't own. We didn't have individual ownership. We didn't have individual ownership.
Oh, fantastic.
Yeah.
It's a good lesson I have
And
learned.
you see, when the British came, they came and landed with individual ownership. They wanted to own individually. Why? Because they were coming from a place where the king or the queen owned everything and gave it to the barons and the lords and the, And so even there was a constraint. And then they had now moved on in their culture to now individual ownership, where even poor people could own, even if you are not a lord or a lady. So when they landed with, am I going to get a title?
I know.
Because I don't want it to also belong to the king.
It's true.
Like it was happening on the other side. So
that's a very interesting lesson.
So it's not that Africans were afraid of death. We are afraid of death just like the next person, like everyone else. I think the reason we don't write wills is because, we are not convinced. I should be sharing, I should be determining after I'm gone. And also, even when somebody writes a will, we feel they shouldn't have written. And then we come and
start questioning. There's a will that is written and people are still going to court. No, it should not have been this way.
Always the question is, yes. And that's another thing. People say, oh, my will be challenged. But very few challenges succeed. If the will is well done and professionally done, challenges don't usually succeed. But there will be witnesses. But there won't be a shortage of people challenging.
It's
Why?
true.
Because deep inside we feel they are gone. Why are they telling us what should happen to
and
their property?
Entitlement.
It should come back. It should come back to us. But not all challenges succeed. In fact, the person who is claiming that the will was fraudulent or the person who wrote the will was of unsound mind, they have the duty of proving that person was actually of unsound mind or that the will is fraudulent. It's not just saying it's a fraud and then the court agrees with you. Okay?
The burden of proof
is on you to prove that that person was of unsound mind.
See, I know burden of proof. You do. Burden of proof.
Yeah, and there's a case that we love to rely on as lawyers called Banks versus Goodfellow. I had to throw in a case.
No, of course.
And this person used to believe that he was being chased by evil spirits. So his will was challenged on the basis that he believed, and it was not in doubt, that he believed that he was being chased by evil spirits.
Oh, well, I'm going to go and look for it.
Do you know what the court said, though? That from reading his will, it doesn't seem like the chasing of the evil spirits affected how he wrote his will. So his will was valid.
Oh, wow.
Yeah, so even if you are you think, oh, I have mental health challenges, depressed, I have this and that, and that will be the challenge for my will. No. If Banks versus Goodfellow, if the person in Banks versus Goodfellow, the court said, no, they're from reading his will. If he had given his house to one of the evil spirits.
That now would have.
Now that would affect. But the fact that he believed he was chased by evil spirits did not invalidate his will.
It didn't reflect on his will.
Yeah, it did not invalidate the will. So what you need to be aware of is, yes, not all challenges. Challenges don't necessarily mean that the court will accept the challenge. That the court will invalidate the will just because somebody will challenge, and we will not stop challenging, because deep inside in our psyche we believe that once the person is gone,
they're gone.
It should be it should be up for grabs, and we really need to think about it. We need to have a conversation. I feel like we should have a national conversation. I suspect it will be done when I'm gone, maybe when I'm 100.
No, you should make that conversation happen.
Yeah, we need to think about it, because like I did a very sad case of my client's husband passed on. They were newlywed. They were about, they had been married for less than a year.
Oh, wow.
They'd been married for about 2 years because he passed on their child's first birthday. And then his mother wanted everything. They were young, so there wasn't even that much to be shared. But his mother was wishing away this wife, as if she was not there,
all that would have come to me.
That would have come to me. So can she then, can she
just get out
disappear,
of the way.
Get out of the way?
Yeah.
And she really tried to put pressure on the young girl to get on the young lady to get away. You're young, you have an income, you will make the money, give me my sons, whatever my son, and and she was saying, you know what?
They come very entitled.
But we have a child.
I know.
I'm holding this for your grandchild.
Yeah.
Do you know what she said? even that grandchild bring the grandchild. Like you disappear.
It's our child.
Do you see why we need a national
I know,
conversation?
we do need to have a... Leah, you can start that national conversation. It needs to happen. I know people who have gone through that and they have had to fight. I keep saying I don't like confrontation, so I'm like, oh Lord, if I ever find myself in that. I know somebody who really, really had to fight for the rights of their child, their children, because when the husband died, the family sopped in.
Yeah,
And went into the office, broke the office, they got into the safe, they got the titles, they got everything. So I think I agree with you, it's a conversation that needs to be had.
True, true. Once somebody owns property, even if they don't leave a will, if they don't leave a will, their spouse is supposed to hold that property in trust for their children.
And spouse is somebody who you're legally married to.
Yeah, you're legally married to, but there is an anomaly in our law.
Tell me more.
So it should be your spouse. If there's no will, it should be your spouse holding in trust for your
children.
For the children, for your children. I don't know if they also hold in trust for their own children.
That's
who are not your children.
So the law is not very clear on that.
Well, the law says if the children were brought in by the deceased person, if they were taken in by the deceased person, then they can also benefit if they prove. You see, the children of the deceased do not need to prove that they were depending on the deceased. Just being the children of the deceased is enough. But children who are brought in need to prove that they were dependent on the deceased.
Okay.
All right. But that's not even the big anomaly. The big anomaly in our law is that under Section 3.5 of the Law of Succession Act, and I really hate to speak about this section. I actually often forget to speak about this section, but I think that it's important that we speak about it. Under Section 3.5 of the Law of Succession Act, it says there are people who are married after death. So they may not have been legally married when the person was alive.
Yeah.
But once the person dies, they can be considered to be legally married. And wives. I think I don't know if there's been an attempt to introduce husbands, but some husbands have benefited from that provision. You marry somebody, you marry them in church.
Yeah.
Okay? So they are the legal wife.
Yeah.
But then
and they have the certificate.
Yeah, they are the ones, they have the certificate. But then I think in the 80s, I want to say maybe late 70s, early 80s, when the Law of Succession Act was being made, the legislators were worried, the lawmakers, they were worried that, a lot of people come from up country. You have a customary law wife. Up country, there's a lady you married in your youth.
You
and
have
a customary
children.
law.
Yes.
Then you come to the city and you marry somebody else in church, and she has a certificate. Then if you pass on, the customary wife is shocked that she knows you have another wife, but she's shocked that by the concept that this new one
gets everything.
Is the one. No, she doesn't get everything. But this new one is the legal wife and she's not. So at that point in our history, in the wisdom of Parliament, they decided that wife in the village, let's think about her and let's not say she's not. She's not a legal wife. But who are we? We are who we are. So what we've done is we've switched that so that you marry somebody in church, it's a solid marriage, or at the registrars, you have a civil marriage. Or, you have a Hindu marriage. You have a marriage that is a monogamous marriage. You're not supposed to marry somebody else. But years down the line, you go and pay dowry for somebody.
Yes, that has been happening a lot.
You go and pay dowry for somebody.
Yes.
So as long as you're alive as a man, do you know they can't claim to be your wife? Why? You didn't have capacity to marry them because you're married to somebody else under monogamy.
Wait, I know some people whose dowry has been paid. I'm gonna be very
So as long as you're alive, which is why I hate talking about Section 3.5. I wish it didn't exist. I forget to talk about it a lot. I forget about it because I wish it away. The other day I was somewhere, I gave a talk and I didn't mention it. And the lawyer came to me and told me, why didn't you mention it? Because I guess I wish it didn't exist. But it does.
Wow.
So now you've paid dowry. He has another wife.
She's
a wife under monogamy, because if you marry somebody under Christian, Hindu,
civil.
or civil, you're not supposed, when you go and pay dowry for somebody else, that marriage is illegal. That second marriage is illegal.
Wow.
But it is illegal as long as you're alive. So
Yeah.
this person who's been paid for dowry can't come and claim spousal maintenance. They can't claim that you're a wife. But once you're dead, the law of succession, section 3.5 kicks in. Gears change. And that wife is actually considered to be a legal wife because of section 3.5. But did you hear what was my thinking about section 3.5 and why to put in place? Which is why people you thought were monogamous always show up. You know, there's usually a Lee funeral at the back.
And that's how we actually chose.
It's Lee funeral. You didn't know they had 3 wives. As long as they were alive, you knew the one wife that, you know, that is a public wife. But then when the person passes on, there's Lee funeral and 3-4 wives because of section 3.5 of the Law of Succession Act, which allows them. So I say marriage in Kenya is voluntary until you die. And then now you can have posthumous. Other people can come and claim to be your wife and they will succeed. So,
what do they need?
But there has been there was one case of the husband. There was one case where it was the husband who now came and said he was a husband and he succeeded.
This conversation has been so rich. It's been so amazing. I have personally learned so much. We have not even finished. This section, what again? We need to have a high tea about it. This one we need to invite a few ladies and just talk about it because I don't think most people know. Yeah. I know so many people whose dowry has been paid.
And he has another wife.
Yeah. There's now the one who holds.
But you see, the thing is, I feel about that is that it's unfair on that first one because she holds that certificate.
I know.
She doesn't know who's going to come out of the woodwork when the person is gone.
Yeah.
And that this is section 3.5 is one we really want to hold on to. When there have been talks about, there have been several bills planned with the intention of amending the Law of Succession Act. But I never see a bill that touches on section 3.5. So there was a recent bill that said, you know, a wife is a wife for purposes of the Marriage Act. But it still doesn't remove 3.5, which says anyone who is married under another system of law can come and claim to be a wife. So wifehood can be challenged. Now, sometimes people come and claim to be a wife, and then they are told they are not a wife.
Yeah.
But because of section 3.5, it brings in, you see, when you talked about peace, it creates opportunity for chaos because people can come in and claim. But if we were clear, you're either a wife or you're not, then it would reduce it would reduce those fights. You know, somebody would know, well, I'm with this person, I'm not a wife. You know, but the fact that they'll go to a lawyer and be told, oh, under section 3.5, you're a wife, you're a posthumous wife. When you were alive, he was alive, you were not a wife, but now you...
Oh, wow, you pay dowry, treat me badly, you die. Somebody's coming for those things.
Exactly, yeah.
Oh, wow. Anyway, Leah, this has been really, really rich. We are going to continue this conversation because we have not talked about so many things. We've not talked about how do you divide property that was held in the first marriage. Now we have a second marriage. And then how do you do all that? I feel like we have not even scratched the surface on how to protect the legacies long after you're gone, how to protect your peace, how to ensure that the family that you're leaving behind is not left in dysfunction. And they're not left fighting. You can take forever building a family together and ensuring that they're cohesive and everything. And then after you're gone, it falls apart and it's all not worth it. So I invite you to engage with us and let us know what other topics you would like for us to discuss with Leah, because my goodness, we have a lot to talk about. The law in Kenya is very interesting. Leah, do you have a parting shot for us?
My parting shot is to say, protect your family. You know, I think, fine, they may not be perfect, but they're your family. When you don't plan, what happens is that this property is now available to other people. When you don't write a will, other people will come and claim to have been your dependents. The will allows you to say so and so and so and so is my dependent. Other people, just because I paid school fees once when you needed it, or I gave in your harambe, does not make me, does not make you my dependent, you know. So protect your family. They may not be perfect, but they are your family.
It's true.
When you don't plan, that property lies idle. It falls to, you know, fraudsters, and then also people don't know. Your children could be starving or no school fees, and you have a property sitting somewhere, which will then be passed to the Unclaimed Financial
Yeah.
Assets Authority. Actually, I tell people that there's so much money being held by the Unclaimed Financial Assets Authority that the UFA, which is, it's a government entity, but it is a donor.
Oh.
Yes, it has so much money that it is a donor.
And the money
So
they're donating are money that should be feeding, educating.
Yeah, that could be feeding. So your family may not be perfect. Your spouse, your children may have broken your heart in various ways. But it's better to have a plan that protects them rather than the money going to UFA, to the Unclaimed Financial Assets Authority, and then, I mean, however your family is, they are your family.
It's true.
It's better for them to have it than for it to go back to the government.
Yeah.
Because, they are your family.
It's true. You work so hard, and then for what? You're working so hard for your family. We're going to share with you contacts for Leah because she's an expert clearly, and she can tell you so much more. She will help you put your will together. She will help you put a trust together. And whatever it is that you need to do to protect your family's future and give you peace beyond the grave. I am Wanjiru Mwangi. This has been a very interesting episode, and I shall be back. Thank you for joining us, and please engage with us. Follow us on all our social media handles. We are on LinkedIn. We are on Instagram, Facebook. We are on Spotify. We have a YouTube channel. So please follow us, subscribe, click on that bell. See you next time.